Beyond the Maritime Veil. A journey through law, language, and personal sovereignty. From mind control to conscious sovereignty. Matthew Gilbalt, IFC. Disclaimer. This book is provided for informational and educational purposes only. The perspectives, interpretations, and analyses presented herein are offered as subjects for contemplation rather than as legal or financial advice. The author is not a legal or financial professional, and nothing in this book should be construed as professional counsel in these areas. The conversations captured in this work explore alternative viewpoints on legal systems, financial structures, history, and governance that may differ from mainstream interpretations. Readers should undertake their own research and due diligence to come to their own conclusions about these matters. When making decisions that may have legal or financial implications, readers are strongly encouraged to consult with qualified professionals in the relevant fields. The author makes no representations or warranties regarding the accuracy, completeness, or validity of the information presented. Any actions taken based on the content of this work are solely the responsibility of the reader. This book does not advocate for any particular course of action regarding legal or financial matters but rather presents concepts, historical contexts, and alternative perspectives for the reader's consideration and further investigation. Prologue: The Invisible Cage. There is a story about how to catch a monkey. You place a banana inside a narrow-necked jar. The monkey reaches in and grasps the banana, but with its fist closed around the fruit, it cannot withdraw its hand through the narrow opening. Unwilling to release what it thinks it has gained, the monkey remains trapped, not by the jar but by its own refusal to let go. This ancient parable reveals a profound truth about human freedom. Often what imprisons us is not external force but our attachment to assumptions we refuse to release. You were born free. This is your natural state, not a right granted by authority, not a privilege bestowed by document, but the inherent condition of your existence. Yet from your first breath, a system of interlocking concepts, legal fictions, and linguistic spells began to enclose around you, constructing an invisible cage few ever perceive, much less question. This book is not about conspiracy theories. It is about opening your eyes to the water in which we all swim, the constructed reality that shapes our lives so fundamentally that most never recognize its artificial nature. The systems that govern modern life did not emerge by accident. They represent the culmination of centuries of deliberate design, linguistic engineering, and jurisdictional sleight of hand that transformed free human beings into managed resources. Like the monkey, we clutch desperately to notions that appear valuable but ultimately ensure our captivity. What you are about to read may challenge everything you thought you knew about law, language, and liberty. It may provoke discomfort, disbelief, or even dismissal. This is natural. The mind instinctively resists information that threatens its established frameworks. I ask only that you consider these perspectives with an open mind, testing them against your own experience and reason. This journey is not about escaping responsibility or rejecting all structure. Rather, it is about reclaiming consciousness in a world designed to keep us unconscious. It is about distinguishing between lawful principles based on natural justice and legal constructs designed for commerce and control. It is about recognizing the difference between earning a living and surrendering your life energy to systems that do not serve your highest good. Most importantly, this exploration is about choice, genuine choice that can only emerge from awareness. When you understand the nature of the cage, you gain the power to relate to it differently. You discover that the bars dissolve not through resistance but through recognition. The path to freedom begins with a simple question that natural law has always placed at the center of justice. Who was harmed? When you orient your understanding of right action around this essential inquiry rather than compliance with arbitrary rules, the artificial structures of control begin to reveal themselves. I offer these insights not as final answers but as keys, tools for unlocking doors of perception that may have remained closed throughout your life. What you do with these keys is entirely your choice. Some will use them to transform their relationship with existing systems. Others will use them to create new systems aligned with natural principles. Many will simply find peace in understanding the nature of the construct. Whatever path you choose, may this knowledge serve your highest good and the highest good of all beings. For true freedom, the freedom that transcends legal status or political arrangement, can only be found in alignment with natural law and in service to the well-being of all life. The journey begins now. A new lens for seeing the world. This book emerged from a profound recognition. We cannot solve our most pressing problems using the same frameworks that created them. The challenges we face, from the erosion of personal freedom to the capture of public institutions by private interests, aren't isolated issues but symptoms of deeper structural patterns embedded in language, law, and social organization. What follows is not merely theory but practical knowledge drawn from real-world experience and historical record. It is knowledge that has been systematically obscured, not through conspiracy but through the natural evolution of systems that benefit from human unawareness. Throughout these pages we'll examine how the words we use shape the thoughts we can think, and how linguistic control serves as the foundation for all other forms of control. The difference between two distinct legal jurisdictions that operate simultaneously in our modern world, and why understanding this difference is essential to navigating them effectively. How registration systems like birth certificates create dual identities that allow for the administration of living beings through corporate mechanisms. The symbols and ceremonies that telegraph the nature of authority but remain invisible to those who haven't learned to recognize their significance. The critical distinction between what is legal, compliant with statutes, and what is lawful, aligned with natural justice and harm prevention. Why the concept of sovereign citizenship represents a linguistic trap that prevents clear thinking about human freedom. The natural and universal laws that govern reality regardless of human legislation, and how aligning with these laws creates harmony and effectiveness. This knowledge isn't presented to encourage withdrawal from society or rebellion against necessary order. Rather, it offers a foundation for more conscious engagement, a way to participate in social structures while maintaining awareness of their constructed nature and limitations. Some readers may find these concepts immediately resonant, as if remembering something long known but forgotten. Others may experience resistance, skepticism, or even dismissal. This is natural and expected. I ask only that you read with an open mind, testing each idea against your own experience and reason rather than against received authority or conventional wisdom. The journey through these pages is ultimately one of empowerment through awareness. By understanding the constructed nature of systems we typically take for granted, we gain the ability to navigate them more effectively and to create alternatives more aligned with natural law and human flourishing. Let us begin this exploration not as passive consumers of information but as active participants in the discovery of knowledge that has the potential to transform our relationship with language, law, and liberty. Chapter 1: The Etymology of Control and Word Magic. The Power of Words. Words have power beyond their immediate meaning. They shape our thoughts, direct our actions, and construct the mental frameworks through which we understand reality. Perhaps nowhere is this more evident than in the language of governance and law. Consider the word government itself. Breaking down its Latin etymology reveals something profound. Gubernare, to steer, direct, or rule, from Greek kybernein, meaning to pilot a ship. Mens or mentis, mind, intellect, understanding. Combined etymologically, gubernare plus mens suggests mind control or mental direction. This is not merely a curious linguistic footnote but a revelation about the fundamental nature of governance: to guide, direct, or control the mind and thoughts of those governed. This nautical origin is significant as it conceptualizes governance as guiding or steering rather than controlling or dominating. A ship's governor, pilot, doesn't create the ocean or the winds but works with these natural forces to guide the vessel safely to its destination. Yet when we examine how governance actually functions through legal systems, bureaucracies, and administrative structures, we might question whether this guiding principle has transformed into something more directive, more controlling. Word magic, the sorcery of language. The power of language goes beyond mere communication. It extends into the realm of what might be called word magic or linguistic sorcery. This concept is embedded in our everyday terminology in ways few people recognize. Consider the act of writing itself. We call it spelling, the same term used for casting a magical spell. This is no coincidence. When we arrange letters to form words, we are literally casting spells that influence the thoughts and perceptions of those who read them. Legal documents, contracts, and statutes are particularly potent forms of such spelling, creating binding effects through carefully chosen language. The entertainment industry offers a striking example of this linguistic magic at work. In Hollywood, they hire a cast to perform in productions, creating what we call a screenplay. They produce content for the screen, a word that also means to filter or shield. What exactly is being filtered or screened? Perhaps our perception of reality itself. Even the word Hollywood has esoteric significance. The holly tree has historically been used to make wands for magical practice. The industry casts spells through visual and linguistic enchantment, quite literally using the modern equivalent of a magic wand. Hidden meanings and common terms. The subtle magic of language appears in common words whose origins reveal surprisingly different meanings than their everyday usage suggests. The word baby derives from Babylon, the ancient city associated with confusion of languages and captivity, suggesting that from birth, we enter a state of linguistic confusion and limitation. Adult connects etymologically to adulterate, to corrupt, debase or make impure. To become an adult in our society may imply a form of corruption from our original state. Television combines tele, distant, and vision, sight, literally programming our distant vision, or perception of realities beyond our immediate experience. History can be understood as his story, a narrative told from a particular perspective rather than an objective account of past events. Consent through language. One of the most powerful aspects of word magic is its role in gaining consent. According to certain esoteric traditions, universal law requires that those using magical influence must in some way inform those being influenced, though this disclosure need not be obvious or direct. The entertainment industry exemplifies this principle. When viewers consume media presented as fiction or entertainment, they often give uninformed consent to the programming contained within, sometimes even paying for the privilege. By framing influential content as mere entertainment, the actual psychological and perceptual impacts fly beneath our conscious awareness. This extends to the phenomenon of celebrity worship, encouraging idolization of actors, a word derived from idolatry. Through careful use of symbols and language, populations can be led to willingly participate in systems of influence they don't fully comprehend. The significance of etymology. The study of words and their origins offers us a window into concepts that may have been obscured through time and usage. When we understand that everyday language contains these hidden dimensions, we gain new perspective on the systems that shape our lives. This isn't merely an abstract exercise. The words we use frame our understanding of what's possible, what's acceptable, and what's natural. By examining the etymology and hidden aspects of language, we begin to see how deeply our perception has been influenced by linguistic structures we rarely question. As we progress through this exploration, keep these etymological insights in mind. They provide a foundation for understanding how language itself can be a tool of both enslavement and liberation, a theme that will recur throughout our journey into legal systems, sovereignty, and personal freedom. Chapter 2: Two Jurisdictions: Maritime Law versus Common Law. The Divided Waters of Jurisdiction. At the heart of many alternative legal perspectives lies the concept of dual jurisdictions: maritime or admiralty, law and common law. This distinction is more than an academic classification. It represents fundamentally different approaches to rights, obligations, and the relationship between individuals and authority. Maritime law historically governed commerce and navigation on the high seas. It was a body of law developed to regulate shipping, trade, and disputes that occurred on navigable waters, a realm separate from the land. Common law, by contrast, evolved through judicial precedent on the land, reflecting the customs, traditions, and practices of communities. The critical distinction some scholars and researchers highlight is this: maritime law was designed for commercial entities and vessels, ships, not for living human beings. It operates under different principles with different assumptions about rights and standing. The jurisdictional shift. The more provocative claim is that there has been a gradual, deliberate shift whereby maritime jurisdiction, originally limited to the seas and commercial shipping, has been expanded to cover the land and its inhabitants through a complex system of legal fictions. This perspective suggests that modern legal systems have blurred the lines between these jurisdictions, applying principles of maritime law, designed for commerce, corporations, and vessels, to living men and women on the land without their informed consent or even awareness. The supposed evidence for this jurisdictional shift appears in various symbols and practices within courtrooms and legal procedures, from the gold-fringed flags that some claim denote an admiralty court to the use of all capital names on legal documents, supposedly signifying a corporate entity rather than a living person. The artificial plaintiff, maritime law's absence of injured parties. Perhaps the most profound distinction between common law and maritime/admiralty law concerns the requirement for an injured party. Under common law principles, for a legitimate action to proceed, there must be an actual living injured party who has suffered demonstrable harm. This fundamental principle, that without injury there can be no lawful claim, serves as a cornerstone of natural justice. Maritime jurisdiction, however, operates under a fundamentally different principle. Within this system, a fictional entity such as the state of California, or the United States, can bring charges without any living human being having suffered harm. This creates a system where victimless crimes can be prosecuted by entities that have no capacity to experience injury. Consider a common example. A driver rolls through a stop sign without coming to a complete stop. No accident occurs, no person is harmed, yet the driver receives a citation. The ticket represents an invitation to engage in maritime commerce with a corporate entity called the state. If the individual appears in court, they face charges brought by this fictional entity. When we examine this situation through the lens of natural law, profound questions emerge. Who was injured by the rolling stop? Can the state bleed? Can it experience pain or loss? If there is no injured party because the entity bringing charges is itself a fiction, how can there be a legitimate claim of wrongdoing under natural law principles? This maritime jurisdiction functions as a foreign corporate entity operating not to protect rights or remedy harms, but primarily to generate revenue and harvest human energy through fines, fees, and procedural requirements. It operates for service to self, the corporate entity, rather than service to others, the protection of living beings from harm. The acceptance of such a system represents a fundamental inversion of natural law principles. Under common law, the maxim stands, no victim, no crime. The requirement for an injured party serves as a crucial safeguard against arbitrary exercises of power. When this requirement is removed, as it is in maritime jurisdiction, the door opens to limitless regulation of human behavior without reference to actual harm. This distinction illuminates why understanding jurisdictional differences is not merely an academic exercise but a practical matter of profound significance. By recognizing when one is being invited into maritime commerce rather than facing a legitimate claim of injury under common law, individuals can begin to discern the nature of the proceedings they face and respond from a position of greater awareness. Case examples: legal versus lawful in practice. The distinction between legal and lawful approaches becomes clearer through examining real-world scenarios where these differing principles produce dramatically different outcomes. Property tax foreclosures. Consider the case of property taxation. Under maritime/admiralty jurisdiction, failure to pay property taxes can result in foreclosure and seizure of one's home, even if the property was previously owned outright with no mortgage. In this legal framework, the fictional entity known as the county or municipality can claim ownership over a living person's dwelling based on non-payment of an assessment. From a lawful perspective, several profound questions arise. How can one truly own property if it can be seized for non-payment of taxes? If ownership requires ongoing payment to a government entity, isn't this actually a lease arrangement rather than true ownership? Most importantly, if no one has been harmed by the non-payment, how can the seizure of a home, potentially creating homelessness and genuine harm, be justified under natural law principles? The lawful approach would require demonstrating actual injury before claiming remedy. Who specifically was injured by the non-payment? If the answer is merely the government's budget, this reveals the commercial nature of the relationship rather than a matter of justice or harm prevention. Licensure requirements. Another revealing example concerns licensure requirements. Under maritime jurisdiction, practicing numerous professions without obtaining a license, from braiding hair to providing nutritional advice, can result in fines and penalties, even when no person has been harmed by the unlicensed practice. In a lawful framework, such penalties would be justified only if someone had suffered demonstrable harm from the practitioner's actions. The mere absence of a license, a permission slip from a governing authority, would not constitute grounds for punishment without evidence of injury. This distinction is profound. Under natural law principles, one doesn't need permission to engage in peaceful activity that causes no harm. Under maritime legal systems, however, permission from authority, licensure, takes precedence over the absence of harm. Code violations on private property. When individuals modify their own private property without obtaining permits, such as building a shed, installing off-grid systems, or making structural changes, they often face penalties under legal codes, even when these modifications harm no one and may occur completely out of public view. From a lawful perspective, the question remains: who was harmed? If a person builds a structure on their own land that affects no one else, what natural law principle justifies punishment? The legal system operates from the presumption that permission from authority supersedes natural rights to one's property when no injury to others exists. Medical freedom cases. Perhaps the most personal examples concern bodily autonomy. Legal systems increasingly mandate medical interventions or prohibit certain health choices, while imposing penalties for non-compliance, regardless of whether these personal health decisions cause demonstrable harm to others. The lawful approach would require proving that a specific person's health choice directly caused injury to another identifiable individual before any remedy could be sought. Without such proof of harm, natural law would recognize the inviolable right to make one's own health decisions. The common thread. What connects all these examples is the fundamental difference between two approaches to human interaction. 1. The legal approach asks, was permission granted by authority? Were the proper procedures followed? Did the action comply with codified rules? 2. The lawful approach asks only, who was harmed? What is the evidence of injury? What remedy would make the injured party whole again? This distinction reveals that many legal frameworks have inverted natural principles of justice. Rather than serving to prevent or remedy harm between living beings, they often function primarily to enforce compliance with procedural requirements established by authority structures, requirements that may have little connection to actual harm prevention. Understanding this distinction provides powerful discernment when navigating interactions with legal systems. By consistently asking, who was harmed? One can begin to recognize when proceedings are based on natural principles of justice versus procedural compliance with maritime commercial codes. Chapter 3. The Birth Certificate Enigma. The document that defines us. The birth certificate, a seemingly innocuous document recording the fact of our birth, stands at the center of numerous alternative legal theories. While conventional understanding views it simply as an official record, some researchers suggest it serves a more complex function in establishing our relationship with legal systems. According to these perspectives, the birth certificate does more than record a birth. It creates a legal entity distinct from the living, breathing human being. This entity, variously called a legal fiction, strawman, or legal person, becomes the interface between the individual and governmental/financial systems. The two-person theory. The strawman theory, or legal fiction concept suggests that each person exists in two forms. 1. The living flesh and blood human being with natural rights. 2. A legal entity or corporation created through the birth registration process. This legal entity, often identified by the name in all capital letters on official documents, is said to be the actual party to legal proceedings, holder of obligations and subject of taxation, not the living person. Proponents of this view suggest that when your parents registered your birth, they unknowingly created this secondary legal entity that became property of the state, effectively establishing a system where human beings are administered through corporate legal structures without their informed consent. A matter of recognition and standing. It's important to note that while some mainstream sources dismissively label alternative legal perspectives as conspiracy theories, there are legitimate, recognized legal pathways that acknowledge different forms of standing. The American national status represents one such legitimate framework, a recognized legal designation distinct from both conventional citizenship and the often mischaracterized sovereign citizen label. American nationals are registered in the American National Registry and have a defined legal status with its own standing. This and other legitimate legal designations demonstrate that alternatives to conventional citizenship frameworks do exist and are recognized within the legal landscape. These established alternatives invite us to examine fundamental questions about personhood, legal standing and consent that transcend theoretical speculation. The maritime connection. This connects back to our discussion of maritime law, as the legal fiction/strawman entity is said to fall under admiralty jurisdiction, treated as a vessel in commerce rather than as a living being with inherent rights. The theory further suggests that this system treats individuals as lost at sea in legal terms, presumed missing in the admiralty jurisdiction until they reclaim their standing as living beings on the land. Chapter 4. Symbols of Authority and Their Hidden Meanings. The Language of Symbols. Symbols communicate meaning as powerfully as words and sometimes more subtly. Throughout our legal and governmental systems, various symbols appear that, according to alternative perspectives, may indicate more about the nature of authority than is commonly recognized. The gold-fringed flag. One of the most discussed symbols in alternative legal research is the gold-fringed flag, often displayed in courtrooms and government buildings. While conventional explanations describe this simply as decorative, some researchers suggest it signifies that the court is operating under admiralty or maritime jurisdiction rather than common law. According to this perspective, the gold fringe represents the gold tassel that would historically be found on military flags, indicating martial law or military authority rather than civil jurisdiction. Courts have consistently rejected this interpretation, with judges ruling that decorative elements of flags have no bearing on their jurisdiction. Nevertheless, the prevalence of this symbol across courtrooms has continued to fuel speculation about its significance. The bar and the bench. The physical layout of courtrooms contains numerous symbols worth considering. The bar, the railing separating the public from the proceedings, is said by some to represent the boundary between land and sea, with those called to the bar stepping into maritime jurisdiction. Similarly, the judge's bench, derived from bank in Latin, is interpreted by some as representing the financial nature of court proceedings, suggesting that courts function more as commercial venues than forums of justice. The maritime language of law. Even the language used in legal settings contains nautical references that some suggest reveal their maritime origins. Courts having dockets, a term from shipping. Parties making submissions to the court. Cases being anchored in precedent. The flagship case in an area of law. While these terms have become standard legal vocabulary, their nautical origins raise questions about the historical development of our legal systems and the potential influence of maritime concepts on civil and criminal law. Interpretation versus reality. The interpretation of these symbols remains contested. Mainstream legal authorities dismiss connections between courtroom symbolism and maritime jurisdiction as unfounded, while alternative researchers point to these symbols as evidence of a concealed system operating beneath the surface of conventional understanding. Regardless of which interpretation one accepts, examining these symbols encourages us to look more carefully at the environments in which authority is exercised and to question whether there might be deeper significance to the trappings of power that we typically take for granted. Chapter 5. Legal versus lawful, the critical distinction. Beyond semantics, two different worlds. One of the most profound conceptual distinctions in alternative legal philosophy is the difference between what is legal and what is lawful. Far from being mere synonyms, these terms represent fundamentally different systems of authority and obligation. The lawful realm. In this framework, lawful refers to that which is in accordance with natural law, common law, and fundamental human rights. It concerns itself with matters of inherent justice, harm, and the natural rights of living beings. Lawful matters relate to the substance of right and wrong rather than procedural correctness. The lawful realm is said to be the domain of living men and women on the land, where rights are inherent rather than granted, and where harm to others forms the basis of wrongdoing. Key features of the lawful approach include: focus on actual harm or injury, emphasis on making victims whole, recognition of inherent rights, customary practices established over time, judicial decisions based on precedent, jury determination by peers, public trials, plain language proceedings. The legal domain. Legal, by contrast, refers to that which complies with statutes, regulations, codes, and other written instruments created by legislative bodies or administrative agencies. Legal matters concern technical compliance with procedural rules rather than inherent justice. The legal domain is said to be the realm of legal fictions, corporations, and statutory entities, where rights are granted by authority rather than inherent, and where violation of statutes constitutes wrongdoing regardless of whether harm has occurred. Key features of the legal approach include: focus on rule violation, emphasis on procedural compliance, rights granted by authority, codified statutes and regulations, administrative decisions based on policy, judicial determination by officials, private settlement incentives, technical language requirements. The implications of distinction. If this distinction is valid, it has profound implications. It suggests that many legal requirements may have no lawful force, that compliance with statutes created by governments might be a different matter entirely from adherence to natural law principles that govern relationships between living beings. Under this framework, one might ask, is an action that is legal necessarily lawful? Is it possible for something to be legal yet unlawful, or lawful yet illegal? Examples of these distinctions might include: legal but unlawful, seizure of property for code violations when no one was harmed, prosecution for victimless regulatory offenses, corporate pollution within permitted limits that still damages ecosystems, medical mandates without informed consent, lawful but illegal, providing medical assistance without a license in an emergency, growing food on one's property in violation of zoning restrictions, collecting rainwater in jurisdictions that prohibit it, defending oneself or others in ways that exceed statutory limitations. These questions strike at the heart of our relationship with governing systems and the nature of obligation itself. They invite us to consider whether there might be higher principles of justice and right action that transcend what is merely permitted or prohibited by current legal codes. A matter of jurisdiction. This distinction connects back to our discussion of jurisdictions. The perspective suggests that maritime/admiralty law governs the legal realm of commerce and corporate entities, while common law governs the lawful realm of living beings and natural rights. By conflating these distinct concepts under the general heading of law, we may be missing critical distinctions about the nature of authority, consent, and rights that could fundamentally change how we understand our relationship to governing systems. Practical application. Understanding this distinction allows for more conscious navigation of systems. When faced with a claim or requirement, one might ask, 1. Is this claim based on actual harm to a living being, or merely on technical violation of a statute? 2. Is this requirement serving to prevent injury, or primarily to enforce compliance? 3. Am I being addressed as a living being with inherent rights, or as a legal fiction subject to maritime jurisdiction? By maintaining awareness of these distinctions, individuals can more effectively discern the nature of claims made upon them and respond from a position of greater clarity and sovereignty. Chapter 6. Challenging the Narrative, Beyond Sovereignty and Citizenship. The Linguistic Trap of Sovereign Citizen. Perhaps one of the most revealing linguistic constructs in discussions of alternative legal perspectives is the term sovereign citizen. This label, frequently applied to those who challenge conventional legal authority, contains a fundamental contradiction that illuminates much about how these challenges are framed and dismissed. Sovereignty implies supreme, independent authority, answerable to no higher power. Citizenship implies subjection to or membership within an external authority structure. These concepts are mutually exclusive by definition. One cannot simultaneously be sovereign, having supreme authority, and a citizen, subject to external authority. It's comparable to describing someone as an independent dependent or a free slave, a contradiction in terms that undermines coherent thought. This contradictory term serves a specific function in mainstream discourse. It discredits those who question their relationship with governmental systems by framing their position as inherently absurd or incoherent, while avoiding engagement with the substance of their objections. The American National Alternative. In contrast to the contradictory sovereign citizen label, the American national designation represents a legitimate, recognized legal status that avoids this contradiction. American nationals are registered in the American National Registry and have a defined legal standing distinct from both conventional citizenship and the mischaracterized sovereign citizen concept. This distinction is not merely semantic but represents a fundamentally different relationship with governance structures. One based on clarity about jurisdiction and standing rather than confused terminology. The citizenship contract. What exactly is citizenship? In conventional understanding, it represents membership in a political community with attendant rights and obligations. But from an alternative perspective, citizenship might be viewed as a contractual relationship, one that many enter without informed consent or clear understanding of its terms. If citizenship is indeed contractual, several questions naturally arise. 1. Consent. When and how did we consent to this arrangement? Can valid contracts be formed without informed consent? 2. Disclosure. Were the terms fully disclosed? Were all obligations, limitations, and conditions clearly presented? 3. Consideration. What was exchanged? Was their mutual benefit proportional to obligations? 4. Termination. Is there an option to modify or exit the agreement? What are the procedures for withdrawal? These questions aren't merely academic. They go to the heart of political philosophy and the basis of governmental authority. The social contract theories of philosophers like Locke, Rousseau, and Hobbes attempt to address these issues, but the practical application of these theories in modern nation-states leaves many questions unanswered. The three-layer citizenship model. Contemporary citizenship can be understood as operating on three distinct levels. 1. National citizenship. Defined by 14th Amendment and subsequent legislation. Creates federal obligations and protections. Established through birth or naturalization. Administered through Social Security and related systems. 2. State citizenship. Defined by residence and state constitutional provisions. Creates state-level obligations and benefits. Often automatic with physical presence and intent to remain. Administered through driver licensing, voter registration, etc. 3. Municipal citizenship. Defined by city or county residents. Creates local obligations and services. Generally automatic with residents. Administered through property records, utility accounts, etc. Each layer carries distinct implications, jurisdictions, and relationships. Understanding these distinctions allows for more conscious navigation of the various systems. beyond binary thinking. The conversation about sovereignty and citizenship often falls into binary thinking. Either one accepts the current system in its entirety, or one is positioned as rejecting all order and authority. This false dichotomy prevents nuanced exploration of how systems of governance might better respect individual autonomy while maintaining social cohesion. There exist many possibilities between total subjection and complete isolation. Community-based governance recognizing natural rights while coordinating collective needs. Consent-based systems that make explicit the terms of participation. Jurisdictional clarity that distinguishes between commercial regulation and natural rights. Multiple forms of association allowing for various levels of engagement without all-or-nothing propositions. By moving beyond the limiting labels and exploring the space between total subjection and complete isolation, we might discover more harmonious ways to organize our collective existence while honoring the sovereignty of each individual. Practical navigation. For those seeking to clarify their status and relationship with governing systems, several approaches exist. 1. Status clarification, documenting one's standing through appropriate filings and notices. 2. Jurisdictional awareness, understanding which matters fall under which jurisdiction. 3. Selective engagement, consciously choosing when and how to interact with various systems. 4. Community building, creating parallel structures for mutual support and exchange. 5. Educational outreach, sharing knowledge about these distinctions with others. The goal is not confrontation but clarity, establishing transparent relationships based on informed consent rather than presumption or coercion. The path forward. Moving beyond misleading terms like sovereign citizen, opens space for more productive discussions about the nature of authority, consent, and human organization. By rejecting false dichotomies and contradictory language, we can begin to explore more nuanced frameworks that honor both individual sovereignty and collective well-being. This exploration isn't about avoiding responsibility but about ensuring that relationships are based on transparency, informed consent, and mutual benefit rather than confusion, presumption, and hidden obligation. Chapter 7. Language as the Key to Freedom. The Prison of Concepts. Language doesn't merely describe reality, it shapes how we perceive and interact with it. The words we use create the conceptual boundaries within which we think, and by extension, determine what we believe is possible or impossible, legitimate or illegitimate. If we accept the terminology, categories, and frameworks given to us without question, we may be limiting our understanding in ways we don't recognize. This is particularly true in domains like law and governance, where specialized language serves to both clarify and obscure, sometimes simultaneously. Reclaiming definitional authority. A key insight that emerges from examining alternative legal perspectives is the importance of definitional authority. Who gets to decide what words mean and how concepts are framed? When we uncritically accept definitions provided by systems of authority, we may be surrendering our ability to conceive of alternatives. By reclaiming the right to define, or at least to question definitions, we open spaces for new understanding. This doesn't mean rejecting all established meanings or creating private languages that no one else understands. Rather, it means approaching language with awareness, examining the assumptions built into terminology, and being willing to articulate alternative understandings. The language of consent. Perhaps the most powerful application of linguistic awareness relates to consent. The language of governance and law often assumes consent where it may not have been explicitly given, through phrases like implied consent, tacit agreement, or constructive notice. By becoming more conscious of how language is used to establish presumed consent, we can begin to more clearly articulate where and how we choose to engage with systems around us. This isn't about rejection but about conscious participation, moving from unconscious subjection to aware engagement. Precision in communication. Alternative legal researchers often emphasize precision in language, being extremely specific about terms, making careful distinctions, and clarifying the capacity in which one is speaking or acting. While some of these practices may seem excessive or unnecessary from a conventional perspective, they reflect an understanding that language shapes reality and that precision in communication is essential for clarity of thought and action. By bringing more consciousness to our use of language, particularly in contexts involving authority, obligation, and rights, we may discover degrees of freedom that were previously obscured by habitual patterns of thought and expression. Chapter 8. Natural and Universal Laws, the Forgotten Foundations. The Inversion of Control. One of the most profound distortions in our modern matrix of indoctrination concerns what we can and cannot control. We have been conditioned to believe we cannot control aspects of our lives that are actually within our power, while simultaneously being convinced we control things that are beyond our reach. This inversion creates a state of perpetual frustration and disempowerment. We exhaust ourselves trying to control external events, other people's actions and systemic outcomes, things largely beyond our influence. Meanwhile, we neglect the development of self-mastery over our thoughts, reactions and personal sovereignty, areas where our power is most potent. This strategic confusion is not accidental. When individuals focus their energy on controlling what cannot be controlled, they remain in a state of perpetual failure and dependency. This serves systems that benefit from a disempowered populace seeking external solutions to internal problems. Cause and effect, beyond fear-based thinking. Natural law operates through cause and effect, a principle so fundamental that it exists across all domains of life. Yet our current systems have overlaid this natural law with a framework of fear that distorts our understanding of consequences and responsibilities. Instead of approaching cause and effect with common sense and an orientation toward community well-being, we've been trained to view it through the lens of punishment, compliance, and self-preservation. This fear-based approach replaces our natural inclination toward stewardship of community with a defensive posture centered on individual survival. True natural law reminds us that we are inherently responsible for one another, that the well-being of communities depends on each person recognizing their role as stewards rather than competitors. When we return to this understanding, we see that many laws, imposed by governing systems, are actually distortions of more fundamental principles that would naturally emerge from communities operating in harmony. Division as control, the artificial opposition. Perhaps the most effective method of control is the creation of artificial division. Our current systems excel at positioning people against one another, creating frameworks where survival and success seem to require competition rather than cooperation. This manufactured opposition appears everywhere. In political systems that reduce complex issues to binary choices, in economic structures that pit workers against each other for limited resources, and in social frameworks that emphasize difference over commonality. The result is a population perpetually on the defensive, unable to recognize shared interests or collaborate effectively for mutual benefit. Natural law, by contrast, demonstrates that cooperation and mutual support are the default states in thriving systems. From the cellular level to ecosystem dynamics, natural systems reveal that sustainable success depends on collaborative relationships rather than isolated competition. Fear is the ultimate weapon. The deep entrenchment of fear in human societies represents one of the most powerful weapons for maintaining systems of control. Fear bypasses rational thought, activates our most primitive responses, and makes us susceptible to manipulation in ways that would otherwise be impossible. By maintaining a constant state of anxiety, whether about financial security, social belonging, health, or physical safety, systems of control ensure that most people remain too preoccupied with immediate concerns to question deeper structures or explore alternative possibilities. This weaponization of fear has become so normalized that we rarely recognize its pervasiveness. It influences everything from our media consumption to our educational systems, from our economic choices to our interpersonal relationships. Breaking free from this conditioned fear represents one of the most powerful acts of personal sovereignty possible. The Hermetic laws, hidden wisdom. Among the most profound systems of natural law are the Hermetic principles, a set of universal laws articulated in ancient wisdom traditions but largely erased from mainstream historical education. These principles reveal fundamental truths about reality that transcend cultural, religious, and historical boundaries. The 7 Hermetic principles include: 1. The principle of mentalism. The all is mind, the universe is mental. This principle recognizes that consciousness is fundamental to reality. 2. The principle of correspondence. As above, so below, as below, so above. This principle reveals the fractal nature of reality, where patterns repeat across different scales and domains. 3. The principle of vibration. Nothing rests, everything moves, everything vibrates. This principle acknowledges that all things exist in a state of motion or frequency. 4. The principle of polarity. Everything is dual, everything has poles, everything has its pair of opposites. This principle recognizes that opposites are identical in nature but different in degree. 5. The principle of rhythm. Everything flows out and in, everything has its tides, all things rise and fall. This principle acknowledges the cyclic nature of all phenomena. 6. The principle of cause and effect. Every cause has its effect, every effect has its cause. This principle recognizes that nothing happens by chance or outside the law. 7. The principle of gender. Gender is in everything. Everything has its masculine and feminine principles. This principle acknowledges the creative interplay of receptive and projective energies. These principles do not require belief. They can be observed and verified through direct experience. Yet their systematic removal from mainstream education has deprived generations of a framework for understanding natural law that transcends religious doctrine or cultural programming. Reclaiming natural law in daily life. The path to freedom begins with recognizing and realigning with these natural and universal laws. This isn't a theoretical exercise but a practical reorientation that affects every aspect of daily life. When we understand what we truly can and cannot control, we direct our energy more effectively. When we embrace cause and effect from a place of stewardship rather than fear, we make choices that benefit both ourselves and our communities. When we recognize artificial division as a control mechanism, we can begin to build authentic bridges of understanding and cooperation. When we face and move through our conditioned fears, we reclaim vast amounts of personal power and clarity. And when we study and apply universal principles like the Hermetic laws, we gain access to wisdom that transcends the limitations of our current societal programming. This reclamation isn't merely philosophical. It's the practical foundation for creating lives of genuine sovereignty and communities of authentic harmony. Chapter 9. Private versus Public. The Critical Jurisdictional Divide. Understanding the two realms. One of the most important yet least understood distinctions in our legal landscape is the separation between private and public domains. These represent fundamentally different jurisdictional territories with dramatically different rules, protections, and implications. This distinction isn't merely theoretical. It has profound practical implications for how individuals experience freedom, security, and sovereignty in their daily lives. Banking realities. The credit creation deception. One of the most profound misconceptions in the banking system concerns the nature of loans and credit. The conventional understanding suggests that when we receive a loan, the bank is lending us money from its existing deposits, funds that other customers have deposited or that the bank has accumulated through operations. This understanding is fundamentally incorrect and masks a much more startling reality: self-generated credit through signature. When an individual signs a mortgage agreement or other loan document, they are not receiving money that the bank previously possessed. Rather, their signature itself generates the credit through a process that leverages their own Treasury Direct account connected to their Social Security bond. The process works as follows. 1. Promissory note creation. When you sign a mortgage or loan agreement, you create a promissory note, essentially a negotiable instrument and a form of currency. 2. Self-generated currency. This promissory note, bearing your signature, becomes the actual source of the funds for the transaction. The bank does not lend you their money, your signature creates new money. 3. Monetization process. The bank takes your promissory note, the value you created with your signature, and monetizes it through its relationship with the Federal Reserve System. 4. Bond connection. This entire process connects to your Social Security number, which functions as a bond number in the Treasury system. 5. Double charging. After creating currency from your signature, the bank then charges you interest on the very value that you yourself created. This process represents one of the most significant deceptions in the banking system. Individuals are paying interest on credit that they themselves generated through their signature, connected to their own Treasury account. Signature positioning and contractual status. The position of your signature on a document isn't merely a formality, it determines your standing within the contract and has profound legal implications. Left side signature, debtor position. When you sign on the left side of a document or on a line that doesn't specify your capacity. 1. Debtor status. You are positioning yourself as the debtor in the transaction. 2. Liability acceptance. You are accepting liability rather than preserving rights. 3. Maritime jurisdiction. You are typically operating within maritime/admiralty jurisdiction. 4. Surety position. You are standing as surety for the legal fiction named in the document. 5. Asset vulnerability. Your assets become vulnerable to claims under the contract. Right side signature, secured party creditor. Signing on the right side of a document, often with specific capacity notations. 1. Creditor status. You are positioning yourself as the secured party creditor. 2. Right preservation. You are preserving rights rather than accepting liabilities. 3. Common law standing. You are maintaining standing in common law jurisdiction. 4. Living capacity, you are acting as the living being rather than the legal fiction. 5. Asset protection, your rights and assets receive greater protection. This positioning isn't arbitrary but derives from ancient traditions in contract law where the creditor, the one extending value, would sign on the right, while the debtor, the one receiving value, would sign on the left. Wet ink signatures, the critical distinction. The medium of your signature, particularly whether it is in wet ink versus electronic or stamp form, carries significant jurisdictional and validity implications. Wet blue ink significance. A signature rendered in wet blue ink has special status for several reasons. 1. Authentication. Blue ink provides clear evidence of an original signature versus a photocopy, which appears black. 2. Living authentication. The wet ink contains your DNA and is a direct extension of your living being rather than merely a symbol. 3. Value creation. A wet ink signature on a negotiable instrument creates actual value through the direct expression of your living energy. 4. Jurisdictional marker. Blue ink specifically has been traditionally recognized as appropriate for common law jurisdiction documents. 5. Contract perfection. A properly witnessed wet ink signature creates a perfected contract that cannot be altered without mutual consent. 6. Quantum energy transfer. The physical act of creating a wet ink signature transfers your energy and intent into the document in a tangible form. For a truly lawful and binding contract, wet blue ink signatures provide the highest form of authentication and jurisdictional clarity, connecting the document to your living being rather than merely to your legal person. Private versus public banking. The public banking system. The conventional banking system operates entirely within the public domain under maritime/admiralty jurisdiction. When you open a standard bank account, several key characteristics define this relationship. 1. Depositor status change. Legally, when you deposit money in a bank, you become a creditor to the bank rather than an owner of the funds. The bank becomes the owner of the money with a contractual obligation to repay you. 2. Reportable transactions. All transactions above certain thresholds must be reported to government agencies, with the bank serving as a de facto reporting agent. 3. Asset vulnerability. Funds in public banking systems can be subject to garnishment, freezing, or seizure through various legal mechanisms without your direct consent. 4. Fractional reserve practices. Banks can lend out multiples of your deposit, effectively creating currency from your deposit through fractional reserve banking. 5. Federal Reserve jurisdiction. All transactions ultimately fall under the jurisdiction of the Federal Reserve System, a private corporation operating under federal charter. Private banking alternatives. Private banking operates under fundamentally different principles and jurisdictional frameworks. 1. Private exchanges. Rather than deposits into institutional banks, private banking involves direct exchanges between private parties under private contract. 2. Asset control. Assets remain under the direct control of the owner rather than being surrendered to a third-party institution. 3. Jurisdictional privacy. Transactions occur in the private domain under common law rather than in the public domain under maritime/admiralty jurisdiction. 4. Contractual governance. Relationships are governed by direct contracts between parties rather than by banking regulations and statutes. 5. Asset protection. Assets held in properly structured private banking arrangements may have stronger protection against public seizure mechanisms. Local credit unions versus federal credit unions. Credit unions represent an important middle ground between fully public banking and purely private arrangements. 1. Local credit unions. Organized under state charters rather than federal regulation. Typically smaller and more community-focused. Often have more flexible policies and local decision-making. May offer greater privacy and fewer reporting requirements. Operate closer to common law principles in many interactions. Generally provide stronger member control and local accountability. 2. Federal credit unions. Chartered under federal regulation through the National Credit Union Administration. Subject to more extensive federal oversight and reporting requirements. Operate more firmly within the maritime/admiralty jurisdiction. Still member-owned but with more standardized operations. Provide NCUA insurance, a form of federal guarantee. While both types of credit unions offer benefits over conventional banking, local credit unions generally provide greater jurisdictional independence and operate closer to private banking principles. Their community-based nature often allows for more personalized relationships and greater respect for privacy within the boundaries of their charter. Converting Federal Reserve notes to precious metals. One of the most significant steps toward private banking involves converting fiat currency, Federal Reserve notes, into tangible assets with intrinsic value, particularly precious metals. 1. Jurisdictional transition. Converting paper currency to physical precious metals moves value from the public maritime jurisdiction into the private physical domain. 2. Direct ownership. Unlike bank deposits, where you become a creditor, physical precious metals represent direct ownership of tangible value. 3. Privacy aspects. Physical precious metals can be exchanged privately between parties without third-party reporting or tracking. 4. Wealth preservation. Precious metals historically maintain purchasing power over time, unlike fiat currencies which consistently lose value through inflation. 5. Seizure resistance. Properly held physical precious metals offer stronger protection against asset freezes, bail-ins, or digital financial system disruptions. Key considerations for this conversion include physical possession. Direct possession provides maximum privacy and control. Private storage. Secure, private storage solutions outside banking systems. Documentation. Maintaining appropriate documentation for larger transactions. Form selection. Choosing recognizable, divisible forms, coins versus bars. Authentication. Ensuring authenticity through reputable sources and verification. Converting even a portion of digital assets to physical precious metals represents a significant step toward monetary sovereignty and jurisdictional independence. Property ownership. Allodial title versus fee simple. Fee simple ownership, public domain. Most people believe they own their property outright when they have a deed, but in the public domain, ownership typically takes the form of fee simple title. 1. Superior claims. Fee simple ownership acknowledges superior claims by government entities, typically expressed through property taxation. 2. Conditional ownership. Failure to pay property taxes can result in seizure of the property, revealing the conditional nature of this ownership form. 3. Regulatory subjection. The property remains subject to zoning regulations, building codes, and various restrictions imposed by public entities. 4. Eminent domain. Property held in fee simple remains subject to eminent domain powers of government entities. 5. Deed restrictions. Ownership is defined and limited by the language of the deed, which typically includes numerous restrictions and conditions. This form of ownership exists entirely within the public domain under maritime/admiralty jurisdiction, with the owner effectively holding a superior lease rather than absolute ownership. Allodial title, private domain. Allodial title represents a fundamentally different form of ownership that exists in the private domain. 1. Absolute ownership. Allodial title represents absolute ownership with no superior claims by any government entity. 2. No taxation. Property held in allodium is not subject to property taxation, as taxation implies a superior claim. 3. Jurisdictional independence. The property exists outside maritime/admiralty jurisdiction, instead being governed by common law principles. 4. Historical precedent. Allodial title has deep historical roots, predating modern property registration systems and corporate governmental structures. 5. Land patents. In the United States, allodial title is often connected to original land patents issued by the federal government. Establishing or claiming allodial title involves complex processes that vary by location and circumstance, often including research into land patents, filing appropriate declarations, and establishing the private character of the ownership. Private versus public employment. Public employment. When working within the conventional employment system, individuals typically function within the public domain. 1. Tax withholding. Employers serve as withholding agents for tax authorities, automatically redirecting portions of earnings. 2. Regulatory compliance. Employment relationships are governed by extensive statutory regulations rather than purely by agreement between parties. 3. Corporate structures. Both employer and employee typically operate through corporate legal fictions rather than as living beings in direct relationship. 4. Social security system. Employment is typically tied to the social security system, which establishes a particular legal relationship with government entities. 5. Jurisdictional submission. The entire relationship exists within maritime/admiralty jurisdiction under statutory authority. Private work arrangements. Alternative work arrangements in the private domain operate under different principles. 1. Direct contracts. relationships governed by direct contracts between parties rather than by employment statutes. 2. Private exchange, compensation through direct exchange of value rather than through regulated payroll systems. 3. Common law jurisdiction, arrangements existing under common law jurisdiction rather than statutory employment frameworks. 4. Direct responsibility. Each party takes direct responsibility for their obligations rather than relying on withholding systems. 5. Voluntary association, relationships based on voluntary association rather than regulated employer-employee dynamics. These arrangements might take various forms, from traditional independent contracting to more novel private exchange systems or cooperative structures operating in the private domain. Practical jurisdictional navigation. The distinction between private and public domains is not merely philosophical but practical. Living beings can navigate between these domains with awareness, making conscious choices about where and how to conduct various aspects of life. 1. Explicit declarations, clearly establishing the capacity in which one is acting in any given interaction. 2. Jurisdictional awareness, recognizing which jurisdiction applies to various activities and relationships. 3. Private contracts, using properly constructed private contracts to establish relationships outside public jurisdiction. 4. Asset protection, structuring assets to maintain their private character and jurisdictional status. 5. Intentional documentation, creating clear records that establish the private nature of various activities and relationships. The key to effective navigation is awareness, recognizing the different jurisdictional territories and making conscious choices about where to locate various aspects of one's life and activities. Conclusion: the spiritual journey of sovereignty. As we reach the conclusion of this exploration, it becomes essential to recognize that the journey towards sovereignty transcends mere legal frameworks and jurisdictional battles. At its core, this journey is profoundly spiritual, an awakening to our authentic nature and our place within the greater tapestry of creation. Beyond jurisdictions, the inner awakening. The information presented throughout this book provides practical tools for navigating legal and social systems with greater awareness. Yet these external frameworks merely reflect deeper truths about our essential nature. When we begin to live consciously as peaceful men and women firmly grounded upon the land, something profound stirs within us, an ancient remembering that can't be fully expressed in legal terminology or jurisdictional concepts. This awakening is not about separation or isolation but about integration and wholeness. As we reclaim our natural sovereignty, we simultaneously recognize our profound connection to all life. The jurisdictional distinctions explored in these pages serve not to divide but to clarify, to remove artificial barriers to this recognition of our true essence. Reconnection with divine principles. The path of sovereignty naturally leads toward a stronger bond with the living God and with our planet. This isn't about religious doctrine or institutional alignment but about direct relationship with the divine principles that govern all life. The same natural laws that inform our understanding of justice, harm, and right relationship in legal contexts extend into every aspect of existence. When we align ourselves with these principles, when we orient our lives around truth, integrity, and compassion, we discover that external authorities become increasingly irrelevant. True sovereignty emerges not from battling against systems but from embodying the divine principles that transcend all human constructs. The awakening of sovereignty often coincides with a deepening awareness of our responsibility as stewards of the earth. As we clarify our relationship with human institutions, we simultaneously clarify our relationship with the natural world, recognizing that our well-being is inseparable from the well-being of the ecosystems that sustain us. Objective truth beyond indoctrination. This guide has endeavored to present information that allows for objective discernment beyond the conditioning of politics, government, religious institutions, and societal programming. The goal has never been to replace one form of indoctrination with another but to create space for direct perception and authentic knowing. True sovereignty requires seeing through all forms of externally imposed meaning to discover the essence beneath. This doesn't mean rejecting all structures or traditions but approaching them consciously, retaining what serves life and truth while releasing what distorts or constrains our authentic nature. When we learn to see beyond our programming, we discover that many of the conflicts and divisions that seem so significant from within conventional frameworks simply dissolve. We recognize that beneath the artificial categories that separate us, we share a common essence and a common home. From division to unity. The knowledge contained in these pages should never be weaponized to wage battles against our fellow beings. The purpose of understanding jurisdictional distinctions, legal fictions and linguistic manipulation is not to gain advantage over others but to free ourselves and others from unconscious limitation. True sovereignty leads not toward isolation but toward more authentic community, relationships based on mutual respect, voluntary association and recognition of each being's inherent worth. As we clarify our own boundaries and standing, we simultaneously become more capable of honoring the boundaries and standing of others. The phrase self-governing by the people, for the people points toward this vision of community based on sovereignty rather than subjugation. When each individual stands in their full sovereignty, conscious cooperation becomes possible in ways that hierarchical systems can never achieve. The ongoing journey. This book does not represent an endpoint but a beginning, an invitation to continued exploration, discernment, and growth. The journey of sovereignty unfolds uniquely for each person, guided by their own inner wisdom rather than external authority. As you integrate these understandings into your life, trust your own experience and intuition. Question everything, including the information presented here. Test concepts against your own direct perception of truth. Retain what resonates with your deepest knowing and set aside what doesn't serve your journey. Remember that true sovereignty emerges not from what you know intellectually but from how you live. Information becomes wisdom only when embodied in daily choices, relationships, and ways of being in the world. May your journey towards sovereignty bring you into ever deeper alignment with truth, love, and the divine principles that govern all life. May it lead you toward right relationship with yourself, with others, with the natural world, and with the greater mystery that encompasses all existence. The path is yours to walk. Walk it in peace, integrity, and compassion.